Well, hey, Jordan. So this is Jordan Couch on the line here. And Jordan, you just wrote a nice blog post for us on helping to understand the workers' compensation system here in Washington from the perspective of an immigrant. And I thought we would just walk through some of the stuff that you just wrote about so that folks could better understand it. Jordan, you are a workers' comp attorney in Tacoma, Washington, and work for Pat Pallas, who is the former boss of the entire bar association, which I assume he lets you not forget ever. Want to
Right.
just give us a sense of what you typically do? Like, what is your job?
So my job is essentially helping injured workers get through the system and achieve their goals, whatever those goals may be. So, most of our clients come to us, they've been hurt on the job, they've filed a workers' compensation claim, and now something is going wrong with their claim. They come to us, and it's our job to help them navigate their way through the system so that they can get treated and get back on their feet. I went to law school, graduated a couple of years ago from Indiana. I did a lot of work there helping plaintiffs, and it's something I'm very passionate about is really getting in and helping individuals. So workers' compensation was a good fit for me.
Well, let's start with what I think is the most basic question, and it's a question that I've had myself before, which is, say you are an immigrant and you're either a permanent resident or a visa holder, or maybe you're even completely undocumented and don't have papers in the US. Can you get workers' comp in Washington state?
Absolutely. There's a common misconception that immigration status can have some bearing on a workers' compensation claim, whether it's reducing benefits or making you not entitled to benefits at all. The truth is, immigration status doesn't matter at all. The only thing that the state of Washington cares about is were you injured and is it related to your work? The answer to those questions is yes, you can file a workers' compensation claim, and your benefits are the same as any other citizen of the United States or Washington.
So, just to drill down on that a little bit, sometimes there's what the law is, and then there's the reality on the ground. I know you guys do a lot of work with non-citizens. So, in reality, when you're actually asserting one of these claims for somebody who, let's just say, is completely undocumented, does that come into play at all in the process, or can they pursue their claim just as well as anybody else?
They can navigate their way through their claim just as well as anybody else, but occasionally difficulties do arise. For instance, in trial, if you're actually litigating a case, they're not allowed to talk about your immigration status or even ask about it at all. But before it gets to that stage, you're working with people at the Department of Labor and Industries, and these are state employees who are not as familiar with the law. So they do sometimes ask these questions that are inappropriate and irrelevant. It's important to know your rights so that you know that you don't have to answer those questions because at the end of the day, whatever your immigration status is, they cannot take that into consideration.
So probably all the more reason to have a good attorney so that if they're asking questions that they're not allowed to ask or they're irrelevant, um, you can jump in and say, that doesn't matter. Don't ask my client.
Absolutely. And it's happened before during investigations where they ask these questions. And I have to say, if that's not relevant, you can't ask that question. And I advise my clients not to answer.
So if my client is hurt on the job, something happened, how do they know whether or not they might have a potential claim for workers' compensation?
Whether or not you have a claim comes down to one really simple question, or I guess you can phrase it as two. Am I injured? And is it related to my work? That's the primary question. If the answer is yes to that, then you can file a workers' compensation claim. It doesn't matter, whose fault it is or anything like that. Just are you injured and is it related to your work?
And what would be, let's say something happened yesterday for one of my clients and they call me up because I'm their attorney, even though I don't know the first thing about workers' comp. What would I tell them is step number, I don't know, let's say one, two, and three to make sure that they're protecting their rights?
Step number one is report to your employer that you've had some sort of injury or some sort of accident on the job, or that you're feeling sick from something related to your work. Step number two is the most important step. Go to a doctor. I always tell clients that come into our doors, that the number one thing they need to do is focus on getting themselves treated so they can get back to their lives. Your doctor is the one who will actually diagnose you and say that your injury or your disease is related to your work. This is the essential step. After you've done that, the doctor will help you file a workers' compensation claim. It's a simple form you have to fill out and submit to the Department of Labor and Industries. Sometimes your employer will do that for you, or your doctor will do that for you. So if you have questions, there are easy places to go to get answers on how to fill out that form.
But the doctor actually is the one who helps make that initial claim.
Absolutely. There's a portion of the claim that has to be filled out by a doctor. Essentially, it's one page, and your portion of it says your name, any children, any family you have, and how you were injured. A doctor then fills out a smaller portion that says what your diagnosis is and whether or not that's related to your work.
So some of us have doctors, we've been going to for years. What do you do if you don't have a doctor that you normally see? Maybe you don't have insurance, so you're worried about how you're going to pay for that appointment. If you're relatively low income, where would you start to connect with the right type of doctor for this?
The first thing that's important to know about this is that whether your claim is ultimately accepted or not, your first visit to a doctor when you file the claim is always covered 100% of the time. So for the initial expense of filing a claim, you have nothing to worry about. As far as finding a doctor goes, you have the right in the state of Washington to choose who your doctor is. Sometimes employers will tell their employees, oh, you have to go to this doctor or this hospital. That's not true. You get to choose the doctor who files your workers' compensation claim and the doctor who treats you. If you don't know any doctors, a good place to go is to talk to family members or coworkers who you respect and see if they have any doctors in the area they like. If that doesn't work, go online, search for doctors in your area, and find someone who you feel you can connect with. If it's a serious injury, obviously the first step is to go to an emergency room. Sometimes the nearest emergency room is the best emergency room to go to. But from there, you can still change it later.
So if I call up a doctor and say that I want to have an examination for a workplace injury, do all doctors' offices have some special intake procedure that they use? And so they say, okay, it's a workers' comp claim. We won't charge this guy when he comes in. Is that how it works?
Not every doctor in the state of Washington does workers' compensation claims. Some choose not to, but those who do generally have it as part of their intake process. There's no specialized process you need to go through, but the doctor for themselves will know for billing that when they fill out that workers' compensation claim form, they bill the Department of Labor and Industries directly, and they do not send a bill to you, or at least they shouldn't.
Okay, so basically when you call the doctor, you can figure out whether or not this is a type of, whether it's work that they do or not.
Absolutely.
Okay. So let's say that you go to the doctor, you're obviously injured, that's why you're at the doctor, and it does seem that it's workplace related or work related. What can potentially be recovered if you're that injured worker?
So in the workers' compensation system in Washington, there are generally considered to be 5 benefits you can be entitled to. Not everyone will get all 5, but everyone will get some of those benefits if they have a workers' compensation claim. Number 1 is the most common one. It's treatment. You are entitled to be treated for all conditions related to your injury or subsequent accidents that happen because of your injury. So if you have to get surgery because of your injury and there are complications from the surgery, that is covered as well. That's the number 1 benefit. The second benefit is what's known as wage replacement benefits. There are 2 categories of this. Anytime your injury has you completely unable to work and you can't go into the office or go into the business where you work, you are entitled to get paid 60% of your wages based on your total monthly earnings, and they pay that regularly every 2 weeks as long as you are unable to work. If you're married or if you have dependent children, that 60% number can go up, but 60% is the baseline minimum that they have to pay you. Loss of earning power is the other type of benefits. If you're able to work, but say reduced hours or on a less extensive basis and they pay you a lower amount, you're entitled then to benefits based on the amount you're not making anymore. So if you're making, say, 70% of what you used to make, the Department of Labor and Industries will pay you 80% of that missing portion of your payment to kind of help you maintain your balance. And
Gotcha.
then the
you might have lost me on the math there, but I I caught the drift.
And then the last three benefits that you can be entitled to are, number one is what's known as vocational retraining benefits. Basically, in order for you to be found, for your claim to close, they have to find that you were able to return to work. In most cases, with people with, a cut on their finger or something like that, people go back to the job that they were injured at and they're okay. In more extreme circumstances, they might say that you're unable to return to your job ever again. In those cases, you can be entitled to vocational services where they will send you back to school and retrain you to do a new career for up to 2 years. Last, if you're unable to go back to work, they'll also have vocational counselors help you build resumes and put you in touch with employers who can help you find work.
So deadlines. Lawyers always have to worry about deadlines. What deadlines might an injured worker need to know about if something's happened?
So there are a lot of deadlines in the workers' compensation system, and I find that a lot of my clients have gotten trapped by these. The number one deadline to keeping track of is when to file your claim. With a workers' compensation claim, there are two different types of claims. One is what's known as an industrial injury. This means a specific incident at work caused you to be injured. The other is what's known as an occupational disease. This means that the conditions of your work caused you to have a disease. You can think of this like those who work around chemicals a lot, developing asthma, or those who do very strenuous work that causes a lot of bending of the knees, developing arthritis in their knees. These are what's known as an occupational disease claim. For an industrial injury claim, you have to file your claim with the doctor within 1 year of the accident. With an occupational disease claim, you have 2 years from the date that you discover you have the occupational disease to file your claim. Other deadlines pop up throughout the workers' compensation claim, though. Most commonly, at various points in time, the Department of Labor and Industries will issue what are known as orders. These are binding documents like would come from a judge, but they come from claim managers to the department, and oftentimes they have errors in them. However, if you don't contest that decision within 60 days, that decision becomes final and binding, and there is almost nothing anyone can do to correct that bad decision. If you do qualify for vocational services, they'll make decisions in much the same way by issuing letters. Those letters have to be responded to within 15 days, just that small window of time, or that decision becomes final and there's nothing that can be done with it. It's really important if you
check your mail.
Check your mail, read everything very carefully, and make sure you're on top of any deadlines.
So I guess final topic is what, if any, other additional major pointers would you have for folks early in the process to make sure that they're protecting their claims, and how would they know if they had the type of claim that might need an attorney's help to effectively defend?
Both good questions. So the main thing with a workers' compensation claim, no one ever expects to get injured, so it's always a surprise to people. Take a little time when you first have your claim or when you first get injured to get to know the system in a little more detail so that you understand what your rights are and you know what you're entitled to. That'll help you recognize the red flags for when the department is doing something wrong or trying to deny you benefits. As far as those red flags go, there are a couple big ones that I always point out to people. If ever you're scheduled with a vocational counselor, that means that the employer or the Department of Labor and Industries is trying to close your claim. If you feel that you need further treatment, a vocational counselor being assigned is a big red flag. The other and biggest red flag is what are known as independent medical examinations, or IMEs. Although they're called independent, these are doctors hired by the employer or the Department of Labor and Industries to deny you benefits. These get scheduled for you all the time without communicating with you. So if you get a letter in the mail saying you've been scheduled for an IME or an independent medical examination, know that the employer is trying to deny you benefits. And that's a perfect time to reach out and speak to someone, or at least talk to your doctor about what's coming.
Well, speaking of reaching out to an attorney, Jordan, how would folks get in touch with you, and what does it cost for somebody to sit down with an attorney to chat about their case?
For us, it costs absolutely nothing to sit down and talk with us about our case. And this is something we tell people a lot of the time. If you have questions, talk to an attorney early. It's free, and at the very least, we can help you assure you that you are on the right track with your claim to getting all the benefits you're entitled to. We run a pretty high-tech law firm around here, so if you want to communicate with us, however works best for you is okay for us. If you like to email people, you can find our email address on your website and email us at palacelaw.com. If you'd rather call, it's 253-627-3883. You can call, you can speak with an attorney, who can guide you through and tell you where you are in your case and if you need help or not.
And I guess I should close by picking up on that reference to tech. That's, of course, Jordan, how you and I know each other is through various law tech circles here in the Washington area. And yes, you guys are definitely very progressive in using technology to effectively work with clients. Can clients text you as well? Or did I make that up?
Absolutely. You can text us at our email addresses. Mine is Jordan, Jordan, at palacelaw.com. And you can send it straight from your phone. It goes all the way to us. Our big focus here is on everything we do is for the clients. So we try to make as many options available to clients as possible so that they can do things on their own time with what works best for them.
Yeah, the text thing is pretty cool. Well, hey, Jordan, thanks for taking the time. And we'll be sure to post contact information to you in the YouTube notes to the video. Take care, and we'll
Absolutely.
talk to you soon.